Good morning, Jack.
Good morning, Bob.
So today, I thought we could talk about the most recent order the Supreme Court issued. They stayed a lower court decision that had enjoined the implementation of an executive order the president had issued for large-scale reductions in force in the executive branch, an executive order that was implemented by directive from the Office of Management and Budget. And you and I have had a chance to discuss this offline, and we have some disagreements here. And what's interesting is these disagreements arise in a case in which the court uh, issued this stay with only one dissent. Justices Sotomayor and Kagan joined all the justices except Justice Jackson, who dissented. So let me just lay one proposition on the table and have you react to it. The president issued this executive order, which has sort of a mixed message here, both about reductions in force, but also about, and I'm also taking this together with his remarks after the signing, a desire to see the administrative state dismantled. I think he refers in his remarks after the signing to the destruction of the administrative state. And there is other evidence, and we'll get to some of that evidence shortly. There's other evidence that the goal here is not only a reduction in force to achieve efficiency by slimming down the workforce, but also reorganization of the executive branch. And in fact, the plans that were prepared by agency heads pursuant to the president's directive to OMB and OMB's memo to the agencies, those plans are referred to as reduction in force and reorganization plans. And there's other record evidence, for example, comments by the Secretary of State, Marco Rubio, that this is meant to be a comprehensive reorganization. The president in the executive order refers to a transformation of the federal bureaucracy. And the court stayed the lower court decision. We'll talk about the lower court decision. In a nutshell, its position was the executive order itself was not illegal. The executive order rests on the president's authority to be able to direct these reductions in force, and the executive order itself speaks specifically of reductions that are accomplished consistent with applicable law. I am very concerned that the court here, and I understand the complexities of the decisions facing the court, so I'm going to express this as concerned or say that I'm troubled, that the administration is engaged in gamesmanship that even at this stage, and the case is not ended, even at this stage, the court should not have tolerated. The administration's purpose here, it seems to me, is very clear. The district court attempted to have the administration provide the reorganization plans, and the administration wouldn't make them public, but ultimately the district court wound up reviewing 4 of these plans in camera and concluded that indeed, whether there was a purpose here of reduction in force or not, there was clearly a purpose to pursue a reorganization that raises fundamental separation of powers concerns. And I thought the district court on that point, while I don't agree with every direction that lower court opinion took, I thought the district court opinion on that part was persuasive, and it was affirmed by a divided court of appeals. But I think you strongly disagree that this was the moment for the court to, if you will, confront the administration. So I'm going to turn that back over to you for you to express the grounds of your disagreement.
You've already explained the reasons why I think that what the court did is clearly right. As you said, the executive order and the underlying OMB memo called for reductions in force, which are contemplated by federal law, and other presidents have done it, and there's a process for it, and there's a legal structure that governs reductions in force. And it called for reduction in force consistent with the law. And courts enjoin violations of law. They don't enjoin administration aims and administration goals. They look at actions and they ask whether they're lawful. They don't look at separation of powers concerns and enjoin on the basis of separation of powers concerns. They have to be separation of powers violations. All the court said here was that you enjoined something, that the injunction was, I'm interpreting now, the injunction was massively overbroad. It enjoined what was in effect a directive to do something consistent with the law, and had the impact of shutting down the entire effort of the government to implement this plan rather than focused on the underlying, you talked about some specific plans to engage in specific reductions of force. And the court made clear, Justice Sotomayor, who was with the majority on this, made clear in her enjoining the stay that those issues are, and the order itself made this clear also, those issues are still something that the courts can consider, the particular plans that violate particular statutes in particular instances. There are a whole bunch of legal issues here about whether this should even be in district court rather than before an administrative agency. So I just think that this was a completely easy stay because the district court injunction was massively overbroad and enjoined something that said we have to do this consistent with the law. It's just because of concerns about separation of powers.
Let's talk for a second about the language consistent with law, because the district court addressed that issue. Even the administration, and I, by the way, wasn't able to check this reference, but the administration appears to acknowledge that those are not magic words. And if the executive order is in fact a reorganization order, if the evidence suggests that it is, that that's what it is,
But what does the reorganization order mean? There's
it
nothing,
means
there's nothing wrong with the executive branch reorganizing the government consistent with law. There's nothing magic about a reorganization order.
if the administration is directing that, in effect, congressionally authorized functions and agencies are being shut down as a practical matter, and the district court so found after reviewing the plans and looking at these massive reductions in force, and ranging from 40% to 93%, clearly not done, clearly on the record evidence not done with regard to fundamental questions of efficiency, sort of either division by division or employee by employee efficiency reviews. This was an axe applied to the government, and it's applied to the government in fulfillment of the aim of reorganization, as well as, I assume at the same time, some desire to streamline the bureaucracy. And so the executive order, it seems to me, and particularly given that it also refers to elimination and consolidation, I think those are two words that also appear in the executive order, raises the question of whether it is what it claims that it is. And I don't know why that consistent with law language immunizes the government in these circumstances from a more searching inquiry into what precisely it's doing here.
I don't think it immunizes the government from a more searching inquiry into what it's doing here. I think it doesn't at all, and nor does the court. The court acknowledged that there can be a more searching inquiry into what the government is doing here. But the court said that that had to happen on the level of what was actually happening in the individual agencies. And the problem with the district court injunction was that the district court injunction enjoined the entire effort pursuant to the executive order without regard to whether the entire effort was illegal. And these laws are extremely complicated. I mean, the reduction in force laws are complicated. Whether you have to go to the Merit Systems Protection Board as opposed to the district court is complicated. There are a whole bunch of hard legal issues here that you have to be answering on the ground and not at the level of an executive order, which basically just says, please go as far as you can consistent with the law in reducing the size of the federal bureaucracy. That's basically what it says. And that's what was enjoined. And that's, in my view, just way too broad. I mean, you're focused on, look, we all know what Trump is trying to do. He's trying to, and let's just say, I think he said he was trying to destroy the federal bureaucracy. Let's say that's his aim. He's allowed to destroy the federal bureaucracy as far as he can, consistent with law. He was elected president. I mean, I don't like all of this, but he's allowed to do that. He's allowed to pursue reductions in force as aggressively as he can, consistent with law. He's not the first president by a mile to go as far as he can in achieving a policy goal consistent with law and leaving it to the courts to sort out what's lawful and what isn't. And the problem with this order was it was just massively overbroad. And what the court basically said is come back to us with particular plans and we'll look at the particular discrete law. But this, at the level of abstraction in which you enjoined, it was just too broad. That's the way I read what the court said.
When you say the court gave the plaintiffs in this case the opportunity to come back at some point, by the time they come back, much of what the administration has attempted to accomplish will have been accomplished. And I think that is a legitimate concern of the court. You mentioned the complexity behind the president's presidential authority to fire employees, reduce in force, the role of the Merit Systems Protection Board, and all of that is true. It is precisely that complexity that the administration is attempting to exploit toward the goal of basically displacing Congress's role in a reorganization that by history, um, Congress has insisted and rightly insisted that it be part of. And the court reviews a history of presidential reorganizations that I think underscores how unprecedented what this administration is doing, how unprecedented it is. And I think if you take in the aggregate these tens of thousands of reductions almost immediately affected, I am struck by how rapidly everything moved, and the court found that the government moved immediately to implement these plans. It is really difficult to say that this is, standard issue presidential reductions of force. This is exactly what President Trump said that it was. It's exactly what Russell Vogt, certainly in the OMB memo, strongly implied that it was. It's an attempt to go around Congress, to transform the federal bureaucracy in ways that deny Congress participation. I'll just add one more point. The Vogt memo has two interesting pieces to it that it seems to me would have sort of flashed at least yellow for the court. One is the reference to having the agencies determine, by interpretation of the statute, just exactly what functions of an agency are really authorized by Congress or mandated by Congress. And so there's a clear-cut desire to push extremely hard at the boundaries of what Congress has in fact directed or what it hasn't. And then there's a reference to congressional engagement, whether or not there ought to be or some allowance for some congressional engagement to determine whether Congress would agree or support these particular moves to transform the bureaucracy. These are all efforts to distance Congress, to put Congress back several steps away from what the administration is trying to accomplish. And I view those as yellow lights, which, taken together with the rest of what the administration is doing, these massive workforce reductions that the court found gut the ability of the agencies to function, ample reason for the court to have taken what I agree with you might have been the extraordinary step or perhaps an unusual step in letting the stay remain in place, but I would not have thought it unwarranted.
But so several things. I think you're assuming the answer when you say that the president is displacing what Congress has said here. I mean, that's the question in the case. Does Congress allow this? First point. Second point is, what administration in our lifetime, and certainly in the last 25 years, hasn't pushed its authority against the boundaries of what Congress authorized? I mean, that is standard issue modern presidential practice. I'm not going to march through all the examples because we know them. This is not new that a president is pushing against the boundary of what Congress authorized. The third thing is that, I mean, what is the injunction supposed to do? This injunction basically said the president's not allowed to reduce force. Not allowed, pursuant to this plan, is not allowed to reduce force.
Pursuant to this plan, yes, it does not mean the president can't reduce the workforce.
Right.
That is not.
And this is based on a separation of powers concern. But what do you say, Bob? I mean, what is wrong in general with a president? I mean, what is unusual about a president pushing against the boundaries of congressional power and cutting out Congress? That is not new, as you know.
That is certainly not new, but I think that the answer to that is pretty clear, which is it depends on how they go about doing it and in what area they do it.
And it depends on whether it's law. Don't you think it depends on whether it's lawful or not, ultimately?
Well, of course, it depends on whether it's lawful. And here, I have substantial questions about, I think, the lawfulness of what the administration is doing. And I think the court ought to be alert to and address this kind of stark gamesmanship.
But you're talking at such a sorry.
What would have been I'm sorry. Let me just add this. What would have been the cost to the rule of law of the administration refusing to lift or to stay the lower court injunction? What would have been the cost?
The
The
cost of the rule of
administration
law.
had to go back to the drawing boards and find other ways, which it has already found in other contexts, to fire thousands of federal employees. And it has been successful in,
But Bob,
thousands of
you're
cases.
saying that as if there's something wrong with that. And that's begging the question. Whether firing the federal employees is okay or not. Set aside the policy question about whether you like a larger or smaller federal government. Whether you keep talking about firing tens of thousands of employees, as if that answers the question. It doesn't answer the question. The question is whether doing that is lawful. That is the question. And you can only answer that by looking at this particular reduction in force laws, how they're implemented and the like. You can't join, in my view, it's massive, it's a massively overbroad use of the injunction power. And this is the threat to the rule of law. The president was elected. He's trying to implement a program that he ran on. He's saying do it as aggressively as you can, consistent with the law. They're starting to do that, and it was enjoined at that level. Do it as aggressively as you can, consistent with the law. At that level, there's nothing unusual about what the president did. And the fact that many people have been fired so far, there's a process, there's a legal process for this. And we're sorting out, one of the things we're sorting out in the last 6 months is how does that legal process actually work? Because it turns out there are lots of plays in the joints for an executive branch to take advantage of this legal structure to actually reduce force. But you can't invoke the fact that the aim is to destroy the administrative state. That's not a legally operative concept. And you can't invoke the fact, in my view, that many people have been fired to conclude that there's something unlawful here. That just begs the question.
This is a court action or a Supreme Court decision, whether or not to stay the lower court order.
Right.
It does not end the case.
Right.
This is not a case about the president being denied the authority to do what presidents can do, which is to fire thousands of people. It's a case about the attempt to use reductions in force as a means, with plenty of record of evidence that this is what the administration intends to restructure, reorganize the federal government without congressional participation. The baseline point here is that the administration gaming this process and the complexity of the law to attempt to cut Congress out of a massive reorganization of the federal government raises completely legitimate questions of lawfulness. Now, how the court proceeds at this stage, I grant you, it's a complicated question. But I don't think that administration at this point, in the way it has conducted itself and the gamesmanship it has repeatedly exhibited, frankly, should expect a kind of presumption of regularity. You keep on going back to presidential authority and what other presidents have done. This administration, as you and I have written in other contexts, this administration is doing things lawlessly and in explicit defiance of the courts in some cases that mark it as very much unlike other administrations. And I think that's true in this context of this kind of reorganization effort as well. And I think that there's a hear no evil, see no evil aspect to what the court has done here that I'm troubled by. The district court reviewed the plans that the administration incidentally has refused to release. It reviews those plans in camera. And I think Justice Jackson has a point here. It produced a significant amount of record evidence in a 55-page opinion that what was really going on here is what I have suggested is really going on here. And what would have been the cost? What would have been, as I say, the cost of the rule of law if the court had declined to stay the lower court ruling? The administration still would have proceeded apace to try to do in other ways what it wants to do. It's shown that it's at least relentless in the pursuit of these aims. But the court would have put up a significant yellow flag against this kinds of gamesmanship with what I think have significant separation of powers implications.
Okay, so I think we're circling around some of the same arguments. So I'll just give a brief response, and then I have a question to ask you.
Okay.
Cost of the rule of law is that you would be enjoining presidential action that has not been established to be unlawful. The cost of the rule of law would have been that the courts themselves, which are bound by the rule of law and have limited authority to issue injunctive relief, would have issued an overbroad injunction. Cost of the rule of law is the court went through the legal factors and by an 8-1 decision concluded that the government was likely to succeed on the merits of its claim at the level of the executive order and the OMB memo. And it didn't say this, it said the other factors were established, but under Trump versus Casa, the decision the other day, the government clearly suffers irreparable harm here. So the cost of the rule of law would have been that the courts themselves were acting beyond their authority. I mean, I think that's one point. Second point is, listen, I agree with you. We've been writing for 6 months about the unlawful things that the Trump administration is doing, but that doesn't mean that in the cases, therefore, that where they're not acting unlawfully or where it hasn't been established that they're acting unlawfully, that they should be enjoined on an overbroad basis. So the question I want to ask you is, I mean, if this is such a damaging decision to the rule of law, why did Kagan and Sotomayor go along with it? I think that's pretty good evidence that this is not a kind of startling separation of powers result. And the reasons Justice Sotomayor gave are the ones I've been making. I mean, I'm basically making the argument she made, which is the only thing before us is the executive order and the OMB memo, and not the underlying plans. And as the order suggested, and as she made clear in her concurrence, those underlying plans can still be challenged, and we're not saying anything about those things. And that's basically the argument I've been making. She was basically saying that this injunction was overbroad and needs to be stayed. And so I don't understand why Sotomayor, of all people, who's not been shy about going after the conservative majority in cases where she thinks they're acting unlawfully, would have gone along with this.
I certainly don't think Sotomayor is shy about going after the conservative majority. I don't disagree with that. All I can say about the decisions by Justices Kagan and Sotomayor to join the decision is, yes, there was a path for them to follow, and you've laid it out here. And also, I think these justices, overwhelmed by this administration's conduct and the issues that the administration's conduct raises, has to pick its battles. And maybe this is a battle they decided not to pick. Maybe they concluded that later down the line, they could address the core illegality that they were concerned with. That may be the reason. I'm not ranking this along with other conduct by the administration that I view as lawless. I don't know where it sort of fits on the list. But this much I would say, I think that this kind of gamesmanship with significant separation of powers implications has to be addressed. And I do not believe that letting the injunction stay in place, declining to issue the stay, would have been, somehow a vindication of the principle that courts have to respect, lines and authority that they possess. All of the courts right now are confronted with, extraordinary challenges, and they're doing the best they can. The judge in this case went painstakingly through the record evidence and came to the conclusion that what the administration was claiming to do was not, in fact, what it was doing. And I think there was ample evidence for that. And I do not think that it would have been costly to the government, irreparably harm the government in any way whatsoever, if the lower court decision had been permitted, as affirmed by the United States Court of Appeals of the Ninth Circuit, had been left standing. Do I think it is the worst possible of all outcomes? I can't say that. I think we'll see what happens, for example, in the Department of Education case out of New York, which is still pending before the court, where the administration has declared that its intention is, in fact, to close the Department of Education, and we'll see where that goes. But again, and we've talked about this, the court is risking the outcome that by the time they get around in this complex situation to addressing what you describe as the core illegality, the administration will have done something no administration in our history has done before. They will have substantially reorganized the federal government without congressional participation, and the courts will have permitted it to happen.
But we'll see. I'm certainly not going to be able to convince you otherwise. We'll see what happens. I do believe that the Trump administration is going to, and they are in the midst of significantly reorganizing the federal government. In part, they're doing that because they're taking advantage of the fact that these laws have a lot of play in the joints. A lot of what's going to happen is that even as the Supreme Court has ruled in different contexts, a lot of what's going to happen is that to the extent the administration is acting unlawfully, the redress is not going to be in federal court. It's going to be before the Merit Systems Protection Board, which the administration itself has already denied a quorum through firing. There are lots of plays in the joints that the administration is very cleverly exploiting here. But, so I do think they're going to succeed in reducing the size of the government. And the only question for me is that I just don't see this like a lot of their clearly illegal actions. For example, in my view, in the birthright citizenship case or in the law firm's case or in the TikTok case, this strikes me as pretty standard executive. I mean, again, it's aggressive, but it's in the realm of things where the president is saying, go as far as you can, consistent with the law. That's what I want to do. And at that level, and then let the courts tell us where the line is, looking at the law fully. I think that's what this case is. And in that sense, it's very much like what presidents have been doing for the last 25 years.
Well, I suppose that I guess that's the ground of disagreement between us about how it compares to past practice. I'll just mention one other thing.
But let me just make clear one thing. I don't
Yes.
mean past practice with use of force reduction. I'm talking about Biden's student loans or Obama's Clean Power Plan or a lot of the really aggressive things that Trump did in his first term. I mean, the point is that presidents, as we know, this is a common practice now for presidents to push their authority as far as they can, pursuant, you talk about Congress being cut out, but pursuant to what Congress has authorized and allowed, push it as far as they can and see let the court sort it out. Now, I mean, I don't love that pattern overall, but that's where we've been for a while now. And I see this class of cases, even though it's in a different context, it's in reducing the size of the government. I see this class of cases like those other cases. That's what I'm trying to say.
And let me close just with a couple of points. First of all, because we've written a book together on this, that I see Trump as in many cases radically going beyond, and in other cases exploiting what presidents before him had done in a number of areas that we identify in the book that we wrote. And as you know, I take a dim view of some of those expansions or at least claims of expanded
As
presidential
do I,
authority.
but not here.
Right. But here, I think we are seeing, as you say, cleverly exploiting was the language you use. Here you're seeing, in a complicated situation, this president, in effect, attempting to cut Congress out of a massive reorganization of federal government, historic in nature, frankly, in my view, with a gamesmanship that could not be clearer, and which I think the district court very clearly and persuasively lays out. I do not think, had the court uh, declined to issue the stay here, that any major harm would have been done to the institution of the presidency. Reductions in force would have continued. Maybe the executive branch would have been prodded into being sort of more direct, sort of more willing to engage with Congress around these reorganization issues. By the way, the court points out that this administration has attempted to get Congress to approve reorganization plans, to be involved by statute in reorganization efforts, and Congress has declined to do it. So the administration is going to go about and try to do it its own way anyway. And I think that, again, I can't explain why Sotomayor and Kagan joined it, but I'm sure they had their reasons. I respect them both. I respect the difficult position the court has been put in, but I think the outcome is not a happy one, and I think we're going to come to regret it.
All right. Well, I don't think I'm going to be able to persuade you on the law, so maybe we should stop there.
But I will continue to reflect on what you said, I promise.
As will I about what you said. Thank you,
Very
Bob.
good. Hey, very good. Bye-bye.